Profesores. We will now begin the seminar, International Arbitration in Lithuania, with regard to the Baltic as a strategic area in international trade. We thank the following jurists for their participation: Vigita Bebatrie, Vitautas Vaisikauskas, Albertas Sextelo, and Rimantas Simaitis. We now give the floor to Professor Vigita Bebraitier, who will have the honor of moderating the panel. Professor Vigita Bebraitier works at Vilnius University Faculty of Law. She is a professor in the private law department, and her research areas are civil procedure, ADR, and international civil procedure. She's also on the list of arbitrators of Vilnius Court of Commercial Arbitration. She's also vice dean for studies at Vilnius University Faculty of Law. Go ahead, Professor.
Yeah, so buenas tardes in Peru and buenas noches aquí in Lithuania. So now I will continue in English. So it's very nice to be in this Congress and in this panel. And we will speak about arbitration in Lithuania. So I would like to invite and to speak about our three panelists. So first is Professor Rimantas Simaitis. He is a professor at Vilnius University Faculty of Law and also partner and advocate at one of the biggest law firms in Lithuania, Norkus and Partners Cobalt. So he's the head of dispute resolution department and having over 20 of already 30 years of experience in different fields. His field of expertise include litigation, of course, alternative dispute resolution, including mediation and arbitration. And he also works as professor at private law department at Vilnius University Faculty of Law. Second panelist is, I don't know why I see it's Vigita Bebraitier, but it's Albertas Sextelo. So he is also a very famous advocate and arbitrator in Lithuania. He is a partner at law firm Motieka and Tudzevičius, and is really experienced litigator and arbitrator focused on international arbitration and cross-border issues. He also works at our Faculty of Law and is associate professor in partnership. And the first panelist, actually, he will speak. The first one is Vytautas Vaičekauskas. He is our PhD student at Vilnius University Faculty of Law. His PhD thesis he's writing on obtaining information in civil procedure, and he also helps to mentor students for William Wyss International Commercial Arbitration Moot Court at our faculty. He also works at law firm Motieka and Tudzevičius and specializes in dispute resolution and especially on commercial arbitration. So in order to present our legal regulation about arbitration in Lithuania and what traditions we have of arbitration, so I invite Vytautas Vaičekauskas to take his floor and to speak.
Thank you, Vigita, for the kind introduction. So again, good afternoon for those joining us from Lima or elsewhere from Latin America, and good evening once again to my colleagues from Vilnius. Many thanks to the organizers for the invitation. It's my pleasure to be here. And as Vigita noted, I will be talking further about international commercial arbitration framework, traditions, culture, and practice in Lithuania. So it will be from a knowledge from a lot of places, from legal doctrine, from my experience, from my senior colleagues, when I talk about the practice and about the traditions and about the culture. But before that, I want to shortly introduce that Lithuania is a civil law tradition country. It's a EU member state, and so we have a court system for civil cases where we have on top the constitutional court, which overlooks all judicial systems. And then especially for civil cases, we have the general jurisdiction courts, top down, beginning with the Supreme Court of Lithuania, then continuing with the Court of Appeals of Lithuania. And then we have 5 regional courts and district courts. So all of this ecosystem of judicial authorities interact with arbitration, and that's how the legal system of Lithuania is somewhat shaped. And so as to arbitration, arbitration in Lithuania as such, as we today refer to in a modern sense, did not exist until the 1990s, when Lithuania restored its independence. After 1990s, we have Lithuania, who joins the international community once again. First, it joins the New York Convention and the ICSID conventions, and in 1996, the law on commercial arbitration is passed by the Lithuanian parliament. And this law in itself, it is based on 1985 UNICITRAL model law on commercial arbitration. So turning to the legal framework as such, the last major reform of this law took place back in 2012, when the law on commercial arbitration was aligned with the latest amendments of the UNICITRAL model law back in 2006. And after that, we could, so to say, that Lithuania had the legal framework for international arbitration as it stands for international standards around the globe. What actually kept, since then, we didn't have major reforms for arbitration, but we could say that arbitration law was not kept back by that, because even though Lithuania is a civil law country, and we do follow the statutes a lot, we do have a development of case law, and we do have an effect of a precedent. And therefore, in that sense, Lithuanian arbitration practice, Lithuanian case law has caught up with the international trends, especially with the ones coming from the Court of Justice of the European Union. So going to the law itself, the law on commercial arbitration, as said, it's a cornerstone for arbitration in Lithuania. All proceedings seated in Lithuania are governed by it. But there are some key characteristics which don't necessarily deviate from the UNICITRAL model law, but do define the law as such. So first of all, a high level of party autonomy. Most of the legal provisions are non-mandatory, and the ones mandatory are for ensuring party equality, fairness, and due process. As for arbitrability, that is broad. Under the law of arbitration, there's a list of non-arbitrable disputes, but of course, with the effect of precedent in Lithuania, case law has developed in such way that this numerous clauses list is actually not such, and we do have disputes that are not within this list and are excluded from arbitration. When it comes for arbitration's relationship to the court system, arbitration is overlooked and assisted by a few courts in Lithuania. So Albertas will expand on that, but shortly, Vilnius Regional Court provides judicial assistance for arbitrations. A Court of Appeal handles issues of set-aside, enforcement, and jurisdictional matters, and district courts issue writs of execution. As to the procedural matters, arbitral tribunals under this law actually enjoy a wide procedural flexibility. They can decide on the procedure, they can decide on the language, and tribunals do have some rules on evidence, but they're actually very scarce. As for the challenges to awards, they're limited to the standard grounds under the model law. And as to the last part, for the interpretation of this law, it is the standard of interpretation has to be aligned with the UNICITRAL model law and its amendments. So in a way, Lithuanian courts are encouraged to observe international jurisprudence and comparative practices abroad. So that's that for the legal framework of the Lithuanian arbitration landscape. As to the practices, traditions, and culture of Lithuanian arbitration, I would have around 6 points from what I gather to mention, which in my mind characterizes the Lithuanian arbitration as such. So arbitration in itself, the first point, the view on arbitration is as such that we have to admit that most of these commercial disputes are resolved by courts. Reasons for that are not scientifically found, so to say, but one could speculate that that's either for trust, for efficiency, or simple unawareness of alternative means to resolve disputes. One has to give credit to the courts that there are actually efficient and professional in comparison to some partners in our region, in the Baltics, and in the Central Europe. But nevertheless, arbitration is actually very important for very complex, high-value cross-border disputes, where it states one of the main ways to resolve disputes. Second of all, as to arbitral institutions, Lithuania has an arbitral institution, that's a Vilnius Court of Commercial Arbitration, since 2003, created by a merger of two other arbitration institutions. Per year, it handles around 20 to 30 cases. Last year, there were 24 cases initiated. So in comparison to other institutions, it's not a large one. Compared, for example, even to Viennese VIAC institution, that's half of the amount of caseload in the VCCA court. Nevertheless, it's a flexible, modern institution. Most of the cases, except for one last year, are digital, and it's quite of an institute for our jurisdiction, especially for regional and local disputes. As it comes to foreign arbitral institutions, Lithuanian parties and Lithuanian law firms can be seen in front of the major arbitral institutions, be it LCIA, SEC, ICC. Interestingly, I have heard also about cases in front of Singapore's SIAC, but as a regional hub, SEC remains one of the main arbitral institutions for disputes with a Lithuanian element. Now, third, landmark cases. Lithuania had its batch of cases that shaped Lithuanian arbitration jurisprudence, some of which to mention is Svenska Petroleum versus Geonafta, a landmark ICC arbitration, which ended up in front of the Supreme Court of Lithuania, then Gazprom versus Lithuania, which reached the Court of Justice of European Union and was about anti-suit injunctions. And last of all, recently heard an international stage Veolia dispute, or Veolia saga, however one could call it, which included an ICSID arbitration, a Stockholm arbitration, and proceedings in front of the Supreme Court of Lithuania. So there is a vivid landmark, a vivid landscape of arbitration cases in Lithuania. Now, fourthly, arbitration practice. I would mention actually 3 points. It is, first of all, major law firms do have specific teams dedicated for arbitration, people who specialize in this matter. Second of all, our court system does have experts on arbitration. Only last year, or not last year, but this year, one of our university's academic, Eglė Zemlytė, was appointed to the Supreme Court as a judge, and that marks a significant step forward as an academic who specializes in commercial arbitration joined the judiciary. Last of all, we also have an arbitration committee by the Bar Council of Lithuania, so which also signals how important is arbitration for attorneys in Lithuania. Then, as for the academics and scholarship, there shouldn't be much debate that it's an important subject at the faculties. Major faculties teach the subject. Students travel to Vismut yearly. I travel with them in this case. And also we have practitioners who have specialized LLMs in arbitration. And last, we also have an arbitration journal that is published yearly. Now, lastly, as it comes to the arbitration community, quite a defining element of arbitration culture for any jurisdiction. We don't have such association as, for example, Swedish jurisdiction has, but we do have, for example, Vilnius Arbitration Days that are now international, and we had such superstars like Emmanuel Goyard, we had Gary Bourne, we had George Berman coming to Lithuania to talk about arbitration. And in conclusion, as I'm running out of time, I would say that Lithuania is a very stable jurisdiction. It's a EU member state, a classic model law jurisdiction, which might sometimes, due to the size of the market, that it's a small market, not fit big complex cases, but for local and regional arbitration, Lithuania can be a perfect seat. So thank you for your attention, and I'm giving back the floor to Vigita.
Yeah, thank you, Vytautas. Thank you for your introductionary words. And I think we can continue with Alberto's speech about the role of a court, because Vytautas already mentioned a bit about the role and attitude of Lithuanian courts towards arbitration. So perhaps you can continue. What are the roles and how the courts can help arbitrators, or if even we can help. So please.
Thank you, Vigita, for your kind introduction, of course. And of course, I am very pleased to attend this remarkable event, and thank you for all the organizers to having me here. So, first of all, I would like to start from a bit historical perspective. Looking back, as Vytautas explained, to the adoption of Lithuanian arbitration law, it was quite heavily revised, and the last adoption is in 2012. And that there were 2 points to revise the arbitration law, and I was had a chance to attend informal sessions during the drafting of the new arbitration law. First was to make it in line with the amendments of the UNCITRAL law on which it was based. And second, in terms of my today's topic, in terms of the court assistance, we saw that actually there were many courts involved in helping arbitrations to run smoothly, and we saw that there was different case law praxis and even different pace of helping the arbitrations. And we came with the idea to condense or concentrate the assistance for arbitration at one court. And this court, as Vytautas already mentioned, is Vilnius Regional Court. So after adopting the new or revised arbitration law in 2012, the court assistance is handled at one court, which is, as I mentioned, the Vilnius Regional Court, because on the level of courts we have 2 types of courts of first instance. There are district courts, because we have a lot of districts in Lithuania, and on the upper level the regional courts, but they also served as the courts of first instance, but for more, let's say, complicated or sophisticated cases. And in some cases, Vilnius Regional Court has exceptional competence, and it was decided to grant this court full assistance in the arbitration. And I think this novelty was quite successful, and now we have quite predictable case law, and also it allows for the informal specialization of judges in the Vilnius in Vilnius district court, and that's the experience from the we have from the revised arbitration law, and I think it was very successful exercise. And now moving to the scope of the court assistance in arbitration, it's based on the Unstral model law, and even we have some interpretation rules in the law of arbitration, and one of them says that interpretation of this law and its definitions also shall be subsidiary governed by the Uncitral model law on commercial arbitration as last amended, which means the last amendments of 2006. So even if we have some discrepancies between the law and the Uncitral model law, we can rely, or arbitrators can rely, and the courts can rely on the Uncitral model law as an interpretation tool and source of interpretation. And in terms of the court's assistant, which is also in line with the Uncitral model law, the court, the Vilnius Regional Court, assists on appointment and challenge of arbitrators in ad hoc arbitrations only, because also during the drafting of the law, there were discussions that if we have the institutional arbitration, so it's better to give the appointment and challenge of arbitrations to the institutions to decide. And that's why we came with the solution that the Vilnius Regional Court intervenes only in the ad hoc arbitrations, and only if there is a failure of respective party or parties or the arbitrators to appoint the co-arbitrator or presiding arbitrator. Yeah, and I think that narrowing down the court's assistance to only ad hoc arbitrations and allowing the institutional arbitrations to deal it on their own rules and regulations, it's also very, very good idea, which also help the courts to give assistance really where it really needed. And the second type of the Vilnius regional court assistant or this is enforcing the interim measures of granted by arbitrators. So we fully adopted the latest version of Uncitral model law, which allows the arbitrators to grant quite a wide range of interim measures. And there is a tool in the law to enforce those measures. So then the interested parties should apply to Vilnius Regional Court and get the writ of execution. And of course, there are very limited grounds based on due process and public policy when the court can refuse to grant these writ of executions. But again, these grounds are very narrow and should be interpreted also very narrowly. In practice, however, the arbitrators are quite reluctant to grant interim measures. And for instance, in Vilnius Court of Commercial Arbitration, which is the leading arbitration institution in Lithuania, there is a expedited, there's a procedure for emergency arbitrator when the parties can appoint or the institution can appoint the emergency arbitrator to deal with urgent interim measures by the time when the arbitral tribunal is constituted. And from the point of constitution or appointment of arbitral tribunal, the tribunal takes the lead on granting interim measures. And we have the quite progressive case law where the Court of Appeal explained that when the arbitrators are dealing with the interim measures and in parallel the party applied to the state's court for interim measures, the state's court, which is Vilnius Regional Court, should wait and should give the floor to the arbitral tribunal to deal with the interim measures. So there is quite a high level cooperation between the court and arbitral tribunals. So, but in any event, the party can also apply for the court, asking the court to grant interim measures. And actually, this application is quite cheap, I would say, because the stamp duty for it is 100 euros plus some indexation, if I remember it correctly. And in very brief note about the anti-suiting injunction, Vytautas mentioned the famous and landmark Gazprom case, where the Gazprom applied to arbitration, asking to withdraw the state counterparty from pending lawsuit before the courts, and the arbitral tribunal actually granted the award, ordering the counterparts to withdrawing from the lawsuit pending before the before the Lithuanian State's Court, and this hindered a lot of high-level discussions, even in academic and also in the case law, whether the arbitral tribunal should grant the anti-suit injunction because of the West Tankers case that ECJ, European Court of Justice, had, and this case ended up before the European Court of Justice, and the latter said that the arbitration is exempted from the scope of the European civil procedure regime, how to say, and that's why this shouldn't be an issue. And so, and last point I wanted to mention, speaking about the Vilnius Regional Court assistance, is assistance in forced examination of witnesses and experts that failed to appear before the arbitral tribunal. Then the interested party must get the leave from the arbitral tribunal and apply to the Vilnius regional court, who then assists in this kind of proceedings. And the second level is, as Vytautas mentioned, is about the role in set aside and recognition and enforcement proceedings, and this role is devoted to the Court of Appeal of Lithuania, who deals as the only court with the challenge of the arbitral awards, and also recognition and enforcement of foreign awards. And of course, then there is a second level of review when the interested party can apply to the Supreme Court of Lithuania. But this is an exceptional proceeding. So the grounds for challenge of the domestic awards and recognition and enforcement of foreign arbitral awards are the same, and they are fully based on the New York Convention, Article 5. So we have, and also the same applies to the model law, which also mirrors the grounds of recognition and enforcement of foreign awards with the challenge of domestic award, or set aside of the domestic award. And again, in terms of the practical application for, let's say, set aside the domestic arbitral award, the procedure is in writing, and I forgot to mention that usually all the proceedings, the court, for instance, Vilnius Regional Court assists the arbitration are usually in writing. In some situations, the court can appoint the oral hearing, but usually it's quite expedited and proceedings in writing. And moving back to the Court of Appeal and set aside proceedings, it's also by default in writing, which expedites it, and usually takes about 2-3 months to deal with that. Of course, if there are complex cases, it takes a longer period for court to grant the respective ruling. But actually, it's quite expedited and also relatively cheap, because the stamp duty is 500 euros plus indexation, which is about around 550 or something euros in total. So I think this concludes my very brief overview of the court assistance in Lithuania, and thanks for your attention.
Yeah, thank you, Albertas. And I think because the time is running out, so I would like to invite Professor Rimantas Simaitis to speak about his experiences as arbitrator and as advocate in commercial cases. So, and perhaps about some tendencies in arbitration in the Baltic states and in Lithuania. So please, Rimantas, the floor is yours.
Thank you, Vedita. I'm happy to be here. Thank you for invitation by the organizers, and good afternoon for listeners from Latin America, and good evening for listeners in European continents. Well, let me share my experience as arbitrator or as a practicing attorney. And I would like to talk about 3 main points. The first point is legal framework, which also is a part of experience of users of arbitration from business side and lawyer side and arbitrators as well. Another point is efficiency and flexibility of institutional setup. And the last point is, but not the least, is efficiency and efficiency and reliability of enforcement and court support. Well, it is not easy to speak the last one of three speakers. My colleagues already covered many points, but I would like to shed the light on these three topics, or these three key features of Lithuanian arbitration, maybe providing a little bit more information. So the first point is institutional, not institutional, but legal framework. As you already heard, here in Lithuania, we have very much UNCITRAL model law-aligned legal environment, meaning that almost 90%, how you calculate, of legal environment is totally consistent with model law, and we even in Lithuania included in our national arbitration law subsidiary application of modern of UNCITRAL model law, which is quite unique phenomena, and which very strongly demonstrate that Lithuania lawmaker, the Parliament of Lithuania, and also Lithuanian institutions interpreting arbitration law, they're very much keen in sticking to international standards, international practice in their development. As my colleagues already mentioned, this provision of Lithuanian law is unique with indication that we, in subsidiary way, apply modern law of UNCITRAL with all its following amendments. Meaning, if any new amendment will arise in the future, we subsidiary will apply it here in Lithuania. So you can imagine that it provides quite predictable environment for non-Lithuania to come to Lithuania and have its dispute resolution resolved in arbitration. So if you know how arbitration functions in international context in any other country in accordance to modern law, you will find this setup here in Lithuania as well. Another point and another feature is that Lithuania is for a long period of time a party to the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards of 1958, and what has not been said that Lithuanian courts, in applying this convention, they applied quite a pro-enforcement attitude, the meaning that we try to construe this convention sticking to international standards and commentaries of its application, and as Lithuanian Supreme call it, international arbitration doctrine. So this is not a surprise for us as Lithuanian lawyers to see quotations from well-known stars of arbitration, professors of arbitration in our Supreme Court decisions. And this also very clearly indicates that Lithuania tends to be a part of international arbitration community, in not to deviate, not to establish any peculiar rules which any non-Lithuanian would find surprising here in Lithuania. And this is done for a particular purpose, that judicial, legislators, academic, and practitioners community, we understand the value of remaining very predictable and in line with international standards. So that's one of the main features that determines experience of user from any side you come, from the user as a party to arbitration, from a counselor assisting your client, a party, and from arbitrator, if you are a foreign arbitrator appointed to sit on the panel of this Lithuanian institution, or ad hoc arbitration, for example, having its seat of arbitration here in Lithuania, you know what to expect. And there is no, peculiar rules that, for example, if arbitral award will not be vet in signed, yes, so it will be automatically null and void. Now, so we do not have such rules in Lithuania, and you will not find any mines hidden in the legal framework, legal environment. So there are certain peculiarities everybody should be careful about, but they're quite minor in comparison to all the main standards and principles of arbitration established in international context and domain, that you will find everything set up in quite well-organized shape here in Lithuania. The second point, I would like to talk a little bit about efficiency and flexibility of our institutional environment. My colleague Albertas Šeštela very much talked about courts approach, the court setup, which is also very important here, because courts or courts' interference or non-interference with arbitration, their relationship of arbitration, they play very important role in how arbitration interacts in the particular jurisdiction to which the arbitral seat, for example, of arbitral hearing is connected the next, or if you would like to enforce foreign arbitral award. So that's very important. But another very important angle is what my colleague Vytautas Vaičekauskas already mentioned, is that we have quite reliable institution here in Lithuania. In the past, there have been several arbitral institutions here in Lithuania, and only one of them survived by merger of other institutions. One of the institutions which was not very reliable, I have to tell, was several years ago it was just cancelled and annulled by interference of courts, telling that this institution is not reliable and it shall go to the past. So even Lithuanian system cleaned up and left the only authoritative arbitral institution, and which was established in 2003. So it has already experience of more than 20 years. For us as a state which regains its independence after collapse of Soviet Union of 35 years, it is quite significant. We need to stay. On the other hand, you need to understand that this institution is run by several major shareholders of this institution, being the main business associations of Lithuania. So Lithuanian chambers of commerce, which are part of international chambers of commerce, are stakeholder of that institution, very important one. Lithuanian Association of Banks, Lithuanian Association of IT Companies, Lithuanian Road Carriers Association, and some other significantly visible associations, business associations in Lithuania, are the main stakeholders and no one else. Why? Because Lithuanian legal framework provides that only that type of associations can establish institutional arbitration as an institution in Lithuania. And that was done as well for the legal in our law for purpose, in order to eliminate all unreliable institutions or so-called pocket arbitrations from our legal landscape. And this gives credibility to that particular institution. This institution tries to keep to the best standards of international practice in terms of efficiency, operational capacity, offering of arbitrators to be appointed, yes, and flexibility as well. For example, transparency and arbitration appointments. This institution has an open list of arbitrators which are recommended by an institution, more than 200 arbitrators' names, you can find it. And some of them, they are international stars in arbitration, and they come as an offering, yes, to any user of arbitration. There are, I'd say all the known Lithuanian arbitration communities listed as well in that particular list, but this list is open. You can select any arbitration you wish, who can, practice and tell, I would be able to practice as arbitrator in that institution. An institution with no problem will accommodate that particular arbitration, say there will be no conflict of interest, and this arbitrator will match quality standards or qualification standards identified by the parties if they identify. So that's it. And it's very flexible, it's not closed, it's transparent in terms of offering, transparent offering. And this is also done for purpose for everybody to understand and to feel the transparency, how everything goes in that arbitration institution. Operational efficiency, as my colleagues already mentioned, this arbitration institution established this e-case management system a long time ago, more than a decade ago. And this e-case management system, it operates very well. I have I have very much experience in operating that system, so I love it, I have to tell. And it's even more flexible, more efficient than the e-case system that we have in Lithuania, of course, also for many years. And when you see colleagues, colleagues sitting in the panel of arbitrators and using the system, or colleagues from international law firms coming and trying to connect to the system from a side of a counsel of the party, we say, wow, it works smoothly. It is easy to handle. It's very user friendly, and you very easily can handle it, and there is no need to ask for the parties, for example, to make a micro bundles of the cases, etc., because this particular system can generate all the case file in one PDF index file with push of a button. So you cannot find it in any other institutional arbitration system, such as the Stockholm Chamber of Commerce or International Chamber of Commerce arbitration, etc. Well, why? Because this arbitration institution it's quite, well, small and flexible, and it was able to set up the system without various, big projects, etc. And it works very well. On the other hand, you already had the numbers of cases of that arbitration institution. Were not, well, super high, yeah, let's say 24, 30 cases per year. This is not much. Lithuania were not very large country in terms of population. We're 2.8 million. But in terms of, for example, civil cases, we have a bit more than 200,000 cases in courts. Yes. So in comparison to 20 or 30 cases, well, arbitration is not very visible statistically. But this gives flexibility to the arbitral institution to assist each and every case. And you feel it by the responsiveness of the managers of the case, what attention they do put, how do they organize the case, how they set up everything, how they appoint the arbitrators, and how they allow the arbitrator to fly. And this is also very, very much visible. And if you receive the same quality as you can receive in, well, I would not say International Court of Commercial Arbitration because it's top level, maybe a little bit less quality and higher, but maybe the same quality as Stockholm Chamber of Commerce arbitration institutions and some other regional arbitration institutions, but for a price 3 times cheaper than these other institutions, you should consider coming and then using this Vilnius Court of Commercial Arbitration institution. So it's smooth, it's reliable, it's authoritative, and it works really well. And the last point, I'm closing my speech, is enforcement of arbitral awards, how and courts' intervention in arbitration. My colleague Albert has told that the spheres where the courts can interfere with arbitration is rather limited, and they match international standards because it should be like this in accordance to UNCITRAL model law. But needless to say that court practice has developed this approach to the arbitral proceedings in such a manner that Lithuanian courts, they do not interfere. So they approach the doctrine of non-interference. If the parties agreed to have their cases arbitrated, well, let them do this. We do not interfere. Yes, we assist when needed, when requested, in gathering evidence or securing evidence, interim measures if necessary, well, annulment proceedings, recognition proceedings, that's all period. And in interfering with proceedings, they do not, interfere very much. They do not revise in annulment proceedings or recognition proceedings the merits of the case. They strictly, in foreign arbitral awards recognition, they strictly follow the book of the New York Convention, the restrictive approach of that convention, and they do follow international standards. Not revision on the merits, and statistics demonstrate that as well, because statistically only less than several percent of all the recognition and enforcement of foreign arbitral awards were denied. So more than 95% of all foreign arbitral awards were recognized and enforced successfully in Lithuania. The same statistics, even lower statistics on annulment, relates to annulment proceedings. Around 1% of arbitral awards challenged in front of Lithuanian courts are annulled. 1%, so meaning 99% of arbitral awards, they remain, and this sticks to the principle of single institution or single stage in arbitration, not hearing on the merits in several stages in Lithuanian courts. So if you have arbitral award, most likely it is final, which corresponds to international standards. Okay, there are certain grounds, there are certain exceptions, but needless to say that Lithuanian Supreme Court in several cases developed very international and very internationally based practice, and to some extent, I'd say maybe went to certain extreme, telling that Arbitrators have a liberty to make mistakes in terms of evaluating evidence, in terms of interpreting the law, but if these mistakes, they do not cross the very strict boundaries, for example, identified in international standards, such as model law or New York Convention, well, that's the problem of the parties and arbitrators. They agreed to that because mistakes, they can be made by everything, and they do not intervene. So if you would like to have modern, flexible, cost and time-efficient arbitrations, well, you should use Lithuania. And by the way, as my colleagues already mentioned, in terms of Lithuanian-connected cases, not only this Vilnius Court of Commercial Arbitration is visible here in Lithuania, Lithuanian businesses also tend to subscribe to different other institutional rules, such as ICC, Stockholm Chamber of Commerce Arbitration, VIAC, Singapore, and we used to see that as well. And the last remark, if you want to arbitration work smoothly and flexibly in Lithuania, do not forget to start this arbitration very wisely. And how arbitration starts? With arbitration clause, so-called midnight clause. So please do not draft pathological clauses. If you draft very well-shaped clause, if you, for example, would like to refer your dispute to Vilnius Court of Commercial Arbitration, just read this webpage and copy-paste this model clause, so you will not have any problems. Thank you.
Thank you, Rimantas, for this broad presentation. And actually, you answered many of my questions I prepared. So as the time is running, so perhaps I would like to ask Albertas or perhaps also Rimantas and Vytautas. So what do you think? Is arbitration in Lithuania becoming more popular and as an alternative to courts? And what is the perception of other lawyers, perhaps who are not really into arbitration or by the companies? So do you see the huge potential of arbitration in Lithuania? And for what mostly cases do you see it? And what are the tendencies for the future for arbitration if we reflect broader European practices and so on? So as you are both, I think, on the committee of Arbitration Bar Association, yes. So I think you see also the colleagues, other colleagues, advocates who work with arbitration.
Thanks, Vigita. Actually, as you pointed out, me and Rimantas, we are both at the Arbitration Committee and the Lithuanian Bar Association, and Rimantas is the presiding at this committee. And indeed, we are advocating arbitration, but not only in front of the business, but also in front of our other esteemed colleagues that prefer go to courts rather than arbitration. And actually, we have, as Rimantas perfectly described, we have a perfect setup for arbitration in Lithuania. We have pro-arbitration case law. We have trained courts. We have trained councils. But I think there are two perceptions, or maybe wrong perceptions. One is that there is a kind of sophisticated procedure, and only very limited scope of advocates can do that. This is perception one, and perception two, which was a bit touched by Rimantas as well. There is actually one shot, and sometimes not only advocate counsel, but also the business people actually afraid of this one shot, because for them it's better to go to the court and have one option for the appeal, which is in Lithuania also very narrow. It's not review de novo of the first instance court, but it's limited only on the scope on the appeal itself. And I think this one shot, which for me it's a very great advantage of arbitration, somehow might scare the litigious party who likes to have one, two, or even three chances to plead its case. Thank you.
Thank you.
Let me very briefly add. So, in international context, if you have multinational contract and businesses from different jurisdictions involved, it's very recommended to think about arbitration, whether in Lithuania or you can choose any other institution, if necessary, if Lithuania party to the dispute to the contract process, and you agree to choose the Lithuanian law, so why not to think about it? And another point, I totally agree with Albertas that for a foreigner, that's also important to understand that Lithuanian courts are very efficient. They're very much pressuring on time efficiency, cost efficiency, etc. And they try to provide good quality for very reasonable price. That's why Lithuanian businesses, if they do have domestic disputes, they very rarely think about other alternatives because it works quite well in litigation in courts. But for international disputes, normally, foreign businessmen would not feel very much comfortable in finding his dispute resolved by Lithuanian courts. It's very good alternative to think about arbitration. Yeah, Vytautas?
Yeah, I cannot add much more to Albertas and Rimantas, but from my perspective, so to say, 5 years above me and 5 years below me, the people, the generations, there's more and more people who knows better arbitration, and that's due to the fact of Rimantas, of Vigita, of Albertas teaching arbitration, and students going to Vismut, and I think it's not that these people will only end up in law firm practices. These people will end up in-house counseling, where they will be the people who will be accepting or not accepting this midnight clause for arbitration. So I think definitely in years to come, we will see a rise in arbitration practice, I hope, in Lithuania.
Yes, thank you. And about the trends, I think we have several minutes, so perhaps you can see digitalization, Rimantas already mentioned, and about this e-case system in arbitration. And what other tendencies do you feel we will see in arbitration? Perhaps new European approach. Actually, our European Court of Justice is not really friendly to arbitration in comparison with Lithuanian courts. So perhaps briefly you can say some words. What do you feel will be great tendencies for arbitration? Several sentences.
Well, yeah, just one brief remark that actually by now the European Court of Justice killed the investment arbitration within the Europe. I think for the Latin America, this type of arbitration is also quite important. And the Court of Justice just by ACMEA ruling, Comstroy ruling, said that the arbitrators in the investment disputes do not have competence because in intra-EU disputes between one investor of EU country and second EU country, because this stuff is governed heavily by EU law, and the parties should refer to the domestic courts and with support of the Court of Justice in terms of preliminary rulings. And I think this virus is spreading out, and this August we have the Grand Chamber ruling in sport arbitration, saying that actually the arbitral award cannot have res judicata when it was as a defense of the counterparty. And also what is more worrying, the Court of Justice trying to broaden up the scope of review of the challenged award, not only in terms of very narrow due process and public policy issues which are set forth in the New York Convention, but also by referring to EU law and EU principles, which is very broad, and also referring to possibility to assess the facts in reviewing the arbitral award, which is the most worrying probably part of the of this ruling. And in years to come, I think we will see some other rulings of the European Court of Justice in the sanction-related disputes, which is probably a separate topic to discuss. Thank you.
Yes, so perhaps I think we discussed most of the topics. So thank you very much for Rimantas, Albertas, Vytautas, and muchas gracias for listeners and for organizers, especially Jorge Luis Colantes Gonzalez. So thank you and see you in, I think, Lithuania and perhaps some events. So thank you. Bye.
Bye.
Many thanks.
Thank you
Thank
very
you.
much, doctors. We'll see tomorrow for another panel of this Congress.
Thank you.
Thank you.
Bye.
Goodbye.